amendments in preparation for our decision Monday in the House. How the Senate is going to handle that need to be determined by Monday. And so, Carol, if you would please call the roll.
Representative Alaman. Representative Angelos. Representative Baer. Representative Chestek.
Excused.
Representative Harshman.
Excused. I'm so sorry. Excuse me.
Representative Heiner. Representative Haraldson.
Here.
Representative Pendergraft.
Here.
Representative Provenza.
Here.
Representative Rodriguez-Williams. Representative Smith.
Here.
Representative Yin.
Here.
Chairman Nyman.
Here.
President Beitman. Excused. Senator Guru.
Here.
Senator Rothfuss. Senator Salazar. Chairman Nethercutt.
Mr. Chairman, Matt Obrecht, LSO. Joint Rule 11-3 specifies that you are to have this meeting before the 5th day of the new legislature and to adopt the final rules, joint rules of your legislature by that 5th day, which is Monday. So had this meeting Friday afternoon. We've got 2 rules to present to you. They both have a House and Senate version of each of the joint rules, which is a little strange, but I'll explain why as we walk through each of them. The first one I'd like to take up is the amendment to Joint Rule 14-1M. And this is from the Legislative Tech and Process Committee, Mr. Chairman, and also ratified through Management Council in November. And what this bill does is provide that for amendments to the joint budget bill, that if we walk through it, the new change to 14-1M2A requires that amendment ideas be into either the respective House or Senate Attorney's Office by the conclusion of the Committee of the Whole consideration for the mirror budget bill. So, Committee of the Whole is a 2-day process, so you've got 2 days to get your second reading amendments in for the budget bill, but those close at the conclusion of Committee of the Whole. Then you have got until 10 o'clock the next morning to approve those amendments. So the attorneys will be working all night to get those amendments done in order. They have to be numbered and approved by 10 a.m. the next day. However, you don't consider the second reading of the budget bill on that next day. Those approved amendments then get published to the website, and the public and other members of your House have the chance to review those proposed amendments, and then you consider second reading of the budget bill on the 3rd day. So maybe I'll just put some dates here or some days to this. The way it would likely happen is you would start Committee of the Whole on a Friday. You do 1 day of Committee of the Whole on Friday. You do your second Committee of the Whole on Monday. All of your budget bill amendments need to be into LSO attorneys by the end of Committee of the Whole on Monday. You then need to approve those second reading amendments by 10 a.m. Tuesday morning. Tuesday morning is a dead day. There's no reading of the budget bill that day. Wednesday, you then have second reading of the budget bill. All of your amendments for third reading need to be in by the conclusion of second reading on that Wednesday. And then same thing, they need to be approved and then posted. Well, they just need to be approved by 10 o'clock. We'll post them as soon as we possibly can. And then the final third reading of the mirror budget bill will start that next Friday. So, Mr. Chairman, what this is it'll add 1 day to the budget bill process. Right now, we do it all within a week, all within 5 days. So you're adding an extra day between committee of the whole and second reading. And then you're also requiring amendments to get in earlier so that the public and other members have a chance to read those amendments and formulate some sort of idea what they might be about.
Very good. Thank you, Director. Questions for the Director? Chairman Nethercott.
Thank you, Mr. Co-Chair. Director, can you just help the Rules Committee understand the origin of this request and then also its impact on staff?
Yep, Mr. Chairman and Senator Nethercott, origin of the rule was from Senator Driscoll. And I think in his experience as the immediate past president of the Senate would have liked to have seen a greater degree of transparency in the Senate about when the Senate amendments to the mirror budget bill had to be posted to the website. And so this was his idea. He brought it to Tech and Process. Tech and Process refined it somewhat, worked it considerably, took input from myself, Ian, from Don Richards. And this was the final product of that work. Mr. Chairman, Senator, it will put more pressure on LSO staff that night, the final night of committee of the whole, the final night of second reading, to get those amendments all wrapped up and done, and then on the floor so that members can have them approved by 10 o'clock. It's work that would have been done anyways. It just would have been done likely early in the morning on the next day. So we're just kind of changing. We'll have a late night rather than an early morning.
Yeah, Mr. Co-Chairman, and this is more of a comment, but maybe the director can support that. I do recall there was a lot of commentary from the public agencies and constituents alike about being able to follow all of the amendments on the budget. And I think that's the origin where Senator Driscoll is coming from, is he received a lot of communications from everyone interested or impacted, that there just wasn't enough time to be able to review the amendment, understand its impact on their agency, and be able to provide any thoughtful feedback. And so more time allowing for the public's understanding or the agencies to appreciate those amendments.
Thank you, Madam Co-Chair. Any other further discussion or questions for the Director?
Mr. Chairman, maybe just a couple other things I should clarify. If we look at Joint Rule 14-1M, it talks about amendments that can be submitted for preparation on the day of third reading, and that's 14-1M3. It's on page 71 if you actually have a paper copy of the old rules. It says only the following amendments shall be submitted on the legislative staff for preparation on the day third reading of a mirror budget bill is to begin in the first house. And there's changes within the proposed rule to A, amendments to correct errors identified in the bill, correct errors in previously adopted amendments, and to transfer funds necessary to support the total appropriations contained in the bill. And this remains, amendments sponsored by the chairman of the Standing Appropriations Committee or his designee. So that's important. We've got cleanup amendments, amendments necessary to balance, and then also amendments from the Senate and House Appropriations Chairman respectively can be brought on that third day. And that remains.
Very good.
Mr. Chairman, the last thing I'd like to point out is on page 2 of the proposed amendment is that the requirement for LSO to distribute to the members and public all approved amendments as soon as practically possible after the amendment approval deadline, so that's 10 a.m. on the day before the reading. And then a reading of the budget bill shall start not earlier than 24 hours after the deadline to approve amendments for that reading. So for second reading, You could not start, in my example, if committee of the whole finished on Monday, amendments had to be approved by 10 a.m. on Tuesday. You couldn't start second reading until after 10 a.m. on the following Wednesday.
Thank you for the clarification. Are there any other questions, comments?
And then, Mr. Chairman, I said that was the last thing, but that wasn't true exactly. Just wanted to point the difference
Right ahead,
out.
Director.
Yeah. Wanted to point the difference out between the House and Senate version of this bill. The difference in the House version is that House Rule 11-7, which the House has its own unique amendment deadline for mirror budget bill amendments, and that's contained in 11-7. Well, that will not completely line up with the requirements, the new requirements in 14-1M, so that needs to be repealed. The Senate does not have a corresponding rule, the House Rule 11-7. That's why they're not identical, Mr. Chairman.
Thank you, Director. Any other questions? Clarifications? Did you want to take action on this amendment then, and before we move on, or do you want further information on the other amendments, or?
Mr. Chairman, we may see if, I don't know if anyone from the public wants to
Yeah, we'll
speak on
take
it
public
either,
comment.
so.
Any public comment? So, okay, no public comment. Moving on, what is the pleasure?
Yeah, Mr. Chairman.
Madam Co-Chair.
Just for order, is it the will of the Joint Rules Committee, excuse me, to handle these like bill drafts, each rules, or do you want to do them in total? If so, then I would propose that we, move to adopt 14.1 or 14-1.
It's been moved. Is there a second? Second. Seconded by Vice President Salazar. Discussion. Discussion, seeing none. All those in favor of the adoption of Rule J14-1 signify by saying aye.
Aye.
All those opposed, same sign. Seeing none, motion carries. The rule has been adopted. Moving on to the next, Director Olbrich.
Mr. Chairman, this for the House are amendments to your ethics complaint process joint rule, which is Joint Rule 22-1. For the Senate, it's the exact same rule, except the Senate 2 years ago repealed their Joint Rule 22-1. So the Senate does not have a Joint Rule 22-1, a specific ethics complaint process in place right now. So the rules look different because the House rule is an amendment to your existing rule. The Senate rule is to create a whole new rule, but they're the exact same language within them. So I think I'll probably follow along on the House rule, just because it's easier to follow when you can see what's being added or what's being taken away. Mr. Chairman, this is a result of some work done by a subcommittee of Management Council that held public meetings in 2023 on this issue, and this is the end result of that work of that committee. I think there is at least one member of that subcommittee who's here today, and she may speak to the work of that committee. Mr. Chairman, I think this is a better product, better for the public, fairer for members, better for leadership in each house to be able to fairly investigate and adjudicate a complaint against a member. Is it a perfect product? Probably not, but I do think it's better than what's currently on the books, and certainly better than what's currently on the books in the Senate, which is nothing. So.
Thank you, Director.
Do you want me to walk through this, or do you want to? Okay. Mr. Chairman, so on the House version of the rules, we can see what's new in strike and underline. The new 22-1A are legislative findings, and Tamra developed these, and the subcommittee agreed with them, and a lot, I believe, were from Masons, from language. In what section of Masons? Do you remember?
797, paragraph 4.
In Mason 797, paragraph 4. And what the attempt was, Mr. Chairman, with these was to provide a framework for the public on what complaints were appropriate, what to expect out of the complaint process. We've handled a lot of complaints, and I've been director for 8 years now, and a lot of times, members of the public who file a complaint think they're going to get, either I will dismiss the member from the legislature or you will as speaker immediately upon the filing of the complaint. And so I think what we were trying to do here was to set reasonable expectations to what to expect from the complaint process. The legislature finds that the ethics complaint procedure under this rule allows for receipt and investigation of complaints alleging legislative misconduct by members of the House and Senate. The House and Senate have authority to determine the rules of their proceedings and to punish members for contempt or disorderly behavior in their presence and for conduct that seriously impugns the integrity and general order of the houses. An ethics investigation instituted for the purposes of advancing political interests not connected with intended legislation or any matters upon which a House should act, or instituted merely to subject a member of the House or Senate to public animadversion, which I looked that word up, Tamara used it, and it means essentially public scorn, is not a proper legislative proceeding. The right of the electors to be represented by the candidate of their choosing is essential for the preservation of all their rights and shall be recognized by the houses when considering ethics complaints. The ethics complaint procedure under this rule shall be reserved for substantiated allegations of legislative misconduct, and in all other circumstances, the members of the House and Senate shall be ultimately responsible directly to the electorate. Mr. Chairman, subsection B is also new. Nothing in this rule shall prohibit the House and Senate from taking any action or adopting any procedure to preserve order and decorum in the houses pursuant to the authority granted in the Wyoming Constitution. And the point of subsection B, Mr. Chairman, is a body may decide to take some sort of disciplinary action against a member, some sort of investigation, that has nothing to do with the Joint Rule 22-1 process. Someone could complain directly to you without going through this and say, hey, I'm going to bring a motion on the floor to censure this member tomorrow. And that the Senate may rule that motion in order, or the House may rule that motion in order, even though it didn't follow the 22-1 process. Mr. Chairman, the changes to C states the Speaker or President, as appropriate, shall receive written, signed complaints alleging legislative misconduct. And that's something that presiding officers in the past and LSO has read the existing rule to require that the complaint be in writing and be signed in writing. This rule continues that tradition. D defines what legislative misconduct is. And really, this is a big part of the rule. You can't have an investigation unless there's an allegation of legislative misconduct. And that is defined as a violation of Article 3 of the Wyoming Constitution, a violation of the Ethics and Disclosure Act, a violation of any of the Wyoming Conflict of Interest statutes, violence or disorderly conduct during legislative meetings, sessions, or during the performance of legislative duties, bribes or offers of bribes, a violation of the rules of the House and Senate pertaining to ethical standards for legislators or preventing disorderly conduct, or any other conduct that constitutes a felony. E at the bottom of page 2 describes what complaint alleging legislative misconduct must have in it. It must be in writing. The complaint shall be based on unique personal knowledge. And let me maybe pause there and describe what that is. Mr. Chairman, we have received numerous complaints after we started broadcasting on the internet, our proceedings, or people have seen another post on a website somewhere or on social media, and then they file a complaint based on that. It wasn't anything they experienced personally, or they weren't in an actual situation where they saw it. And it's not saying that it might not be a violation of the rules. They just don't have any individualized knowledge of that situation. And any member could bring a complaint based on that. They could just ask their representative to look into that matter, to investigate it. They don't need to file a complaint under 22-1. And also it becomes burdensome to leadership and to staff to have to treat every one of those as a valid complaint under 22-1. So it has to now be based on unique personal knowledge. That wasn't the case in the old rules. It needs to state detailed facts, specify the actions of the named member which form the basis for the complaint, attach all documentation on which the complaint is based, and identify how the specific alleged violation constitutes legislative misconduct. Again, the requirement in paragraph 3, the complaint shall be signed by the person alleging the legislative misconduct. F, a copy of the complaint shall be provided to the member against whom the complaint is filed. G states the presiding officer, after consultation with the majority and minority floor leader, shall summarily dismiss any complaint which, on its face, appears to be frivolous or submitted for any improper purpose. 2, alleges facts that, if taken as true and construed in light most favorable to the complainant, do not constitute legislative misconduct. And Mr. Chairman, what this is known as in the legal world is under the Federal Rules of Civil Procedure as a motion to dismiss, or Federal Rule of Procedure, 12B6, is a motion to dismiss standard. That you look at the complaint, you say, okay, I'm going to take everything you said is true without any independent fact finding. Even if everything you allege is true, it doesn't meet that definition of legislative misconduct as laid out in the rule, so it should be dismissed. We didn't have this standard in the rule previously, but I've always advised presiding officers that they should view complaints to that standard, and if they found they did not actually allege legislative misconduct, that they were free to dismiss the complaint after consulting with the minority and majority floor leaders. Finally, a complaint can be dismissed if it's insufficient as to form. What that means is if it's not based on unique knowledge, if it's not signed, and if it's not in writing. But those would probably be the 3 big reasons. H is notice of summary dismissal shall be provided to the complainant. J, this is all new. All records, findings, and proceedings, including the filing of the initial complaint, shall be considered confidential information, but the complaint shall be available for public inspection upon the dismissal of the complaint, a referral of the complaint for formal investigation, or other final dispositive action regarding the complaint. And Mr. Chairman, what the effort was there is what we were seeing is a lot of times people would file a complaint. They would then take that fact to the press, and there would be an investigation, and there would be a dismissal of the complaint for whatever reason, and that dismissal then couldn't be made public. The member effectively and the officers who investigated it couldn't provide the reasons why they dismissed the complaint and any of the written documents they produced. And it was constraining. It wasn't giving the public a full picture of what had happened, what sort of work had gone into the investigation, and it also wasn't allowing, in some cases, the member to be fully exonerated, or in other cases, the leadership's displeasure with the member's actions to be fully expressed in a public forum, even if there wasn't a violation of the strict violation of the rule. So that can now happen under that change. K pretty much has conforming amendments, and this is where if the complaint is not dismissed under those standards I just discussed, the presiding officer will forward the complaint to a subcommittee of the members of Management Council from the House, against of which the member that the complaint was filed against is a member of. So for a representative of the House, for a senator, subcommittee of Management Council of the Senate, they review the complaint, determine whether there is probable cause that legislative misconduct has occurred, and make recommendations to the presiding officer. The test for determining the existence of probable cause is whether a factual situation is sufficient to warrant a reasonably prudent person informed of legislative procedure and duties to believe that legislative misconduct has occurred. That's pretty much with a small tweak, the existing probable cause determination. The subcommittee informs the member against who the complaint was brought, that it is reviewing the complaint. The member may submit a written answer to the subcommittee. The subcommittee shall have the discretion to determine what additional evidence, if any, is presented during the course of its review. Unless specifically invited, neither the complainant nor the member against whom the complaint has been filed shall have the right to attend or present evidence at any meeting of the council subcommittee. The review by the subcommittee shall all be in executive session and no record of the hearing will be kept. No determination of the council subcommittee is appealable by any person. If the council subcommittee determines that the complaint alleges criminal activity, the subcommittee may recommend that that further proceedings under this rule be held in abeyance pending completion of the criminal investigation. A finding of probable cause of legislative misconduct or any dispositive action shall require the affirmative vote of a majority of the members of the subcommittee. If it doesn't find that there's probable cause of legislative misconduct, the complaint shall be dismissed and the complainant and member will be so advised. And on the middle of page 5, paragraph 9 here, this is new. If the council subcommittee finds probable cause of legislative misconduct, but determines that the interests of justice and the House would not be furthered by a formal investigation under subsection N of this rule, it shall make an appropriate recommendation to the presiding officer for remedial action. In all other circumstances where it determines probable cause exists, the council subcommittee shall refer the complaint for formal investigation in accordance with this rule. Mr. Chairman, it's probably worth me discussing that one a little bit there. Mr. Chairman, I've been involved, like I said, in a few of these now. A number of them have went to a subcommittee of management council to determine whether there was probable cause that legislative misconduct occurred. The members of that subcommittee had always taken their duties extremely seriously. And they were just bound that if a technical violation of legislative misconduct had occurred, they had to then forward that complaint on to this special investigative committee. And you'll see later on in this rule that this investigative committee is what it is a quasi-judicial proceeding. There's a right to call witnesses, there's a right to present evidence, you can be represented by counsel in that, it'll be open to the public. In some circumstances where maybe legislative misconduct has occurred, that sort of proceeding would not be in the interest of the complainant, of the House, or of justice. And this new provision then gives that subcommittee of management council the discretion to make that determination. And there's also other remedies that may be available to that committee to implement in case-by-case, on a case-by-case determination. Okay, I'm going to kick it into high gear here, Mr. Chairman. M is the Special Investigative Committee, and it is just what I said. It's a quasi-judicial proceeding. The Investigative Committee sits as a trier of fact, just like a court would. 5 senators, 9 members of the House. You can present evidence, you can call witnesses, people would be sworn in that proceeding. Then that Special Investigative Committee makes its recommendations to the full body. And that's whether there was a violation of legislative misconduct and what the appropriate punishment may be if there was a violation, and that can include censure, some other punishment, and even by a 2/3 vote, removal from the body of the member. The end of the rule on page 7 just gets into, and this has happened before, if the complaint's filed against the presiding officer who will be in charge of investigating the complaint, and that's the vice president in the Senate and the Speaker Pro Tem in the House. And then if a member of Management Council is, had the complaint filed against them and it goes to the Subcommittee of Management Council to determine, then the presiding officer shall appoint another member to fill that member's role on Management Council Subcommittee investigating the complaint. Mr. Chairman, sorry that took so long, but I'll take any questions.
Thank you, Director Obrecht. Committee, Representative Bear.
Thank you, Mr. Chairman. Mr. Obrecht, on page 3, line 3, going back to your discussion about being based on unique personal knowledge, sometimes things aren't noticed when you're right there, and sometimes other people later would see something on video, a recording, that type of thing. Does this preclude something that's discovered later from being brought up?
Director Obrecht.
Mr. Chairman, I wouldn't say it precludes Representative Bear anything from being brought up later if the person actually realized in the circumstances that they just didn't notice at the time that they had unique personal knowledge of the situation.
Follow up, Representative Bear.
I'll give you a real-world example, Mr. Obrecht. I was presenting an amendment when we had an event during the special session that I later brought up the potential of a motion for censure. I would not have, because I was speaking, I didn't see it, what happened, but I was severely offended when I found out what did happen after the fact. So in that case, would this process have been precluded? I know that there still would have been the opportunity for the body to consider censure, but to go through this process, would this be precluded?
Director Obrecht.
Mr. Chairman, I don't think so, because you would still have those unique facts that were personal to you. And there's no requirement that I can think of or that could be read into the rules that you would have to have noticed that possible legislative misconduct at the moment it happened.
Follow up, Representative Bear. Good. Other representatives, any questions, concerns, comments? Representative Rodriguez-Williams, please.
Thank you, Mr. Speaker. So on page, where am I at here? Page 4, we talk about the subcommittee. And then, if there's probable cause found, we move into what's referred to as a investigative special committee, in which the investigative special committee is open to the public. Just curious if the original incident that occurs is obviously to the level that's going to get down all the way to an investigative, or come before an investigative committee, and we're moving through the process here. If that subject or that person, that representative, who our senator, retains counsel, are they able to be present at the subcommittee, the original subcommittee meeting?
Mr. Chairman, Representative Rodriguez-Williams, only if that subcommittee was to invite them there. And that's specified in paragraph K3, line 31 on page 4, unless specifically invited, neither the complainant nor the member against whom the complaint has been filed shall have the right to attend or present evidence at any meeting of the council subcommittee.
Any further comment? Follow up? Thank you, Representative. Any others? Questions, comments for the good director? Okay, we'll move into public comment. Anyone out want to chat about what we're chatting about? Ms. Herman. Welcome to Joint Rules Committee. committee meeting.
Thank you, Mr. Chairman, and committee, Marguerite Herman, League of Women Voters. And I just want to thank you for undertaking this. It's been, I remember when the legislature first wrestled with this down at the Jonah Bank building, and it's a long-term thing, and there's been a lot of back and forth. It seems that the current way, I would have to congratulate you, seems to balance the due process rights of both sides of the complaint. I am interested not so much in complaints against each other, but the public's access to understand how to file a complaint and how to pursue it and what their rights are under it. The one thing that, and maybe, I don't know, maybe there's no remedy for it, but legislative misconduct is vague, maybe necessarily so, but what does that mean? So when someone, I mean, and there's been sort of a brief mention of here, so when do you think it rises to that level? Rather than just, I'm offended, or I like it, or whatever. What is misconduct? And maybe you don't want to define it, but it's just kind of inexact. And I know, I'll just make reference to another, I think I was talking to, this was before the Management Council. Does this include behavior outside of a session? So that legislative, I mean, acting as a legislator, as someone elected to a seat in the legislature, is not during a session, is that behavior also subject to a complaint? And I remember we gave a couple of examples to the Management Council. I don't need to go into them now, but just they were by private citizens outside a session. So without a little more direction, it's still going to be kind of hard for the public to know what, they know how to do it now, but what rises to a complaint level so that it actually will receive the full vetting kind of a thing. So I just mentioned that. I think a lot of us can maybe agree on what misconduct looks like, but to the public who might want to access this, I don't know if they know what that is. And again, we don't want a lot of frivolous complaints about, you know, to use up time. So I'll leave it at that. Thank you.
Very good. Thank you, Ms. Herman. Any questions from Ms. Herman, the committee? Seeing none, thank you very much. Appreciate your input. Any further public comment? Going once, going twice. Closing public comment, will of the committee. Bill has been, the amendment has been moved, seconded by Speaker Pro Tem Harrelson. Discussion. I'm so used to saying representative all day.
No worries.
Senator Rothfuss.
Thank you, Mr. Speaker. Mr. Speaker, on and for this rule, you know, a lot of work went into it, and it isn't going to be perfect, but I can say, having been involved in a lot of the 22-1 processes in the past, that there were some limitations on it that caused problems and headaches and challenges, and this updated draft addresses most, if not all of those. So again, we might still have some struggles, but honestly, the flexibility provided in one of the early paragraphs, which says that this isn't limiting, but is empowering, is a good piece. There is more clarity pursuant to the last public testimony in our D paragraph of what is and isn't a violation of legislative misconduct, and this was something that was discussed significantly in the working group. At the end of the day, it isn't necessarily, whether we like it or not, legislative conduct. If somebody says something that we don't like, if somebody's a jerk, you know, there's a lot of things that aren't legislative misconduct, even if we'd like them to be. But at the end of the day, they're duly elected, and it kind of falls back on if you're not violating one of these 7 things that we have enumerated here under the D paragraph, you leave it up to the voters. A lot of it gets left up to the voters. But when you're violating law, when you're violating the Constitution, when you're committing violence, then it comes to the chamber to govern, and this is a much better approach than we had in the past, so I'm very supportive of it. You know, the one consideration that I had as I look at this is whether it should be a joint rule or 2 individual House rules. It's certainly easier to implement as a joint rule and easier for staff to work with. There's a lot of upside to it being uniform between the 2 chambers. But I just throw that out there because at the end of the day, I think it's important to remember that a House governs that House and that we can do that independently. So if there were deviation between the rules, that would not in any way be out of order. I don't think this causes any challenges to pass it as a joint rule at this point in time, and we have some deviation between the joint rules, but I did want to raise that consideration. But I'm certainly in support of this work, and I think it moves us well in the right direction. Thank you, Mr. Speaker.
Thank you, Senator Rothfuss. Any further discussion? Seeing none, all those in favor of adopting joint rules for the Senate and House Representatives 22-1 as amended, please say aye.
Aye.
All those opposed, same sign. Motion carries. Adopted. Mr. Director.
Mr. Chairman, thank you. I will get talking points on both of those joint rules, whoever's going to be the floor manager on them.
Thank you, sir. Any further business that could be properly conducted before this committee? Seeing none, I would entertain a motion to adjourn. Moved. Seconded. We are in adjournment. Thank you very much, ladies and gentlemen.